Well, as I said, we'll be back, and this is part 2. And for those who skipped out to get that little snack, I want you to know I'm here with Bill Wigoda and Linda Jakubs, and we're talking about GALs, child's representatives, and attorneys for the children. Before we left part 1, we were talking about whether or not it's preferred by either one of these fine people as to whether they have children of their own. And I think that the consensus is amongst the two of them and myself that it does not matter, and in fact, it's a big help. But having said that, I want you all to know that I have 2 children too, but I have no grandchildren, and I think that it would be a benefit if I did not have a memory, we'll say, of bringing up the kids, because sometimes you take that into another family, and what you did when you were a parent does not necessarily mean other parents would do the same. We talked a moment ago about what the advantage or disadvantage was as to the GAL or the attorney's rep having children, and I think we come to the conclusion that it's probably a disadvantage. But let me ask you this: when did you first meet with the parents when you're assigned, let's say, the position of a GAL?
Okay, well, again, there's no real set procedure, but if time permits, I like to meet with the parents first. After I review all of the pleadings, I meet with the parents to be able to determine what the disputes are with regard to the children. And then I will meet with the children. I generally meet with the children twice, and this is initially, once with the father or at the father's home, and then once with the mother or at the mother's home. And I do this so I can, A, meet with the children at least twice, because I think that's important. A, because it's a first kind of to break the ice and let them know who I am. And I generally find that the second meeting, they're more relaxed. But I also want to meet with the children twice, so I show neutrality, that not one parent is delivering the children to me, as opposed to the other parent.
Now, Linda, you are going to be representing one of the parties, and I want to know, are you going to coach them before they go meet Bill?
Yes. As a matter of fact, I would, because I do not think I would be performing my obligation to present my client in as strong a fashion as possible. And if the coaching amounts to be respectful, dress well, offer the GAL or child representative something to eat or drink, make sure that he has a comfortable seat in the home, I will for sure. If that amounts to coaching, yes, for sure I'll coach. Will I script? Oh no, I will not script. Never would script a client, but I tell you what, any of the child representatives I have encountered are experienced enough attorneys to be able to smell a phony a mile away, Barry, and anyone who scripts, not coach, but scripts his or her client before a child representatives meeting is setting that client up for eventual failure, because when that child representative sees the facade falling away months down the line, you've created a phony of your own client. Hope that's helpful.
Okay, let's say that your client has a bad habit. When you first were introduced to the client, and every time you've seen the client after that, are you going to tell him to eliminate that bad habit?
It depends on what the bad habit is. If it's a habit of excessive profanity, yes.
Okay.
I'll tell him or her to clean up the act. If it's somebody who smokes cigarettes, I won't say that's a bad habit or just
Right.
It's a habit. And my feeling is that the cigarette consumption is something that will keep the client on an even keel. I'm not going to tell my client to abstain from smoking cigarettes or to lie about the fact of the cigarette usage. Because again, that's scripting, that's changing the client. That's not fluffing him or her up to be as best as he can.
Okay, now let's assume that you do not like the AL that's been appointed by the judge, how do you clear that problem up? You don't want that person appointed. You don't want Bill here appointed.
Okay, well, I have to ask for clarification from you, Barry. Is it that I don't like the person, or I do not find that person to be
Qualified.
good for the
You don't find
case?
him to be qualified for that case.
Okay, well, you also presuppose there that I would permit the appointment of someone I find unqualified or someone who's just not right for this case. That's where you'd stop it. So I don't want to presuppose that someone's already appointed, or so I would let someone be appointed for my client's child who might not be the best match for this case.
Now, how do you stop it?
Stop it right then and there in court. I hate to say it, and it does happen, but I have an obligation primarily to the adult in the case, be it mom or be it dad. I represent mothers and fathers, men and women. So my obligation, first and foremost, is to ensure the strength of my client's case. It is not to become popular amongst my fellow domestic relations practitioners. And I think the judges and I think the other attorneys in court understand that that is my job and that is what they themselves would do as responsible attorneys. If somebody's name comes up in court as a possible appointed child representative and that person is not going to be a good match for either me or my client, or I think even the kids, I'll say so right there and suggest an alternative.
And that would apply even if you had an experience with the GAL as a private practitioner, where they maybe always showed up late in court, or maybe where they didn't return telephone calls, etc.
That is true. That's a
Okay.
true statement.
All right, Bill, let's get back to you for a moment. When you meet with the children, do you meet with the children with the parents present, or is that a decision you make a call on at the time?
Whenever possible, I meet with the children without the parents present. In fact, I keep the parents as far away as possible because I don't want the children to be influenced by anything the parents would say or do. And that's why I meet with them twice. Once when the dad brings the children, or I go to the dad's house, and once when the mom brings them, or I meet at mom's house. But and even if circumstances exist where I have to meet in one of the homes, which is not my first choice, I ask mom or dad, or both of them, to either leave the house or to go someplace else in the house where they can't overhear the conversation.
Okay, now, I've had a psychologist testify, and I've had him on my show before. I've always asked them, when they have young children, do you have toys available for the children when you meet them in the office?
Absolutely. I have crayons, I have toy soldiers, I have dolls. Absolutely, I have them there. Sometimes the kids want to play with them, sometimes they don't. But I have a myriad of different things for different ages.
All right. And I noticed that one judge had a teddy bear in that judge's chambers when he saw children, what we call in camera, where they're not subject to the lawyers coming in, and he sat and he used the teddy bear as an example with the child, so the child would open up and talk to him. I thought that was very interesting. Now, isn't it true, Linda, that you guys, and referring to the group as lawyers, that you have to be a psychologist, you got to be a psychologist, and you got to be a shrink, you got the whole ball of wax? One
of the attractive features, Barry, of being a domestic relations practitioner is that we have to be knowledgeable about a lot of things. Psychology, psychiatry, medications, and if an issue of mental illness comes up, so yes. But then that goes along with business appraisals, with economic speak, with accounting principles. So there's a little bit of everything thrown into this practice. That the child-sensitive aspects are, of course, the most gut-wrenching for any of us practitioners, but it's certainly an interesting and well-rounded practice that we have.
All right, Bill, do you meet with anybody else other than the parents and the children?
Oh, sure. I'll meet if the children are currently in therapy. I will at least talk. I will get releases from the children and/or the parents, and then I will talk to the therapist. I have a case right now where there was a family therapist, and I've spent many hours on the phone with her, and I've read all of her reports. And then, of course, I will sometimes talk to teachers. If there are significant others, boyfriends, girlfriends, new husbands, new wives, I can meet with them or speak with them. Sometimes coaches for various teams, and grandparents very often will be involved, because sometimes, you know, in today's day and age, people live with their parents, live with their grandparents, and sometimes when the court will appoint an evaluator to evaluate the allocation of parental responsibilities, or evaluate allocation of parenting time, which we used to call a 604B. Now I think it's a 610.5 evaluation, which is very extensive. I will talk with the evaluator, and that person is usually either a psychologist or a psychiatrist.
Okay, now then you prepare a report as a GAL, but not as an attorney for the child. And when you prepare this report, in the limited time we have, can you just maybe touch the highlights of what that report is going to have?
The report will set forth who I've met with, what I've done, what the issues are, and how I would resolve those issues in terms of my recommendations.
Okay, and that's a very extensive report, and it also usually starts out with what the case is all about.
Correct.
And what issues that were brought to your attention when you were appointed and so forth. I was going to highlight some of the issues I had from a West Virginia report, which I have right here, which is over 50 pages long, indicating to you the type of work and hard work you guys do in making sure that you do it right. And this report is obviously used by forensic people in evaluating the issues that they may have. Do you have any comments, Linda, as to whether or not you think that this is a good system, that a GAL or a attorney's rep or attorney is appointed, which kind of interferes to some extent with what you were doing before they came into the case?
I have an opinion as to whether I would welcome the involvement of that third professional.
Okay.
That third professional, the child representative, a guardian ad litem. I welcome, in almost all of my cases, that involvement, because by the time the court finds it appropriate, and moms and dads, respective attorneys, find it appropriate to have a guardian ad litem, a child representative, or an attorney appointed, things have really digressed to the point where we need a trained set of eyes to come in and give us some fresh ideas, to reassess what's gone on already in the case and where the problems might be solved better.
I didn't ask you, and I don't have much time here, but I would like to have asked you, your fee is going to be cut into as a result of that third party coming in. So if you give me a real short answer.
That's a okay, good point. Part of me says for the sake of family finances, no, I hate the fact that somebody else is dipping into moms and dads' respective pockets to get paid, okay? But child representatives, guardians ad litem, they deserve compensation, Barry, because they have to put up with a whole lot of us.
Well,
but somebody else has to be paid.
Thank you both for appearing
You're
today.
welcome.
And I want to thank the public out there, and we hope that you enjoyed this very informative discussion with Linda Jakubs and Bill Wigoda, both who are in matrimonial law, and myself, Barry L. Gordon. And we hope that you've got some good information today, so that when your GAL is appointed, or an attorney's rep, or an attorney, you understand where you're going. Thank you for watching You and the Law.